Hey guys, welcome back to another new videos and LawGuru welcomes you. So today in this video we will be discussing about courts of session. In the last video we have discussed the classification of courts. So we will start from the courts of session. In this video we will discuss about appointment of judges of the courts of session, powers and functions of the courts of session, and the section itself where the courts of session or where the provisions of the courts of session is given. So before starting this video, if you have not subscribed my channel, please go subscribe so that you all get CRPC related videos regularly. So let's start this video. Section 9 of the CRPC or Criminal Procedure Code deals with the provisions relating to the courts of session. This section says the state government shall establish a court of session for every session division. Here it is written the state government, any state like West Bengal, Odisha, Maharashtra, Madhya Pradesh, UP, Uttar Pradesh, that particular state government shall establish a court of session for every session division. What does session division mean? The session division, the term session division means any district. So here the state government shall establish a court of session for every district in that particular state. Second point, every court of session shall be presided over by a judge to be appointed by the High Court. Every court of session or the sessions court shall be presided over by a judge. There should be a judge in the court of session that will be appointed by the High Court. Number 3. The High Court may also appoint additional session judges or assistant session judges to exercise jurisdiction in a court of session. So, in this case, in the court of session, there shall also be additional session judges and assistant session judges so that they can also exercise their jurisdiction. Who will appoint them? Obviously, the High Court will appoint them. Fourth point. The session judge of one session division may be appointed by the High Court to be also an additional session judge of another division, and in such case he may sit for the disposal of cases at such places or place in the other division as the High Court may direct. It means that the session judge of one session division or one district may be appointed by the High Court. The session judge of any particular district may be appointed by the High Court as an additional session judge of another division, and in that case that particular session judge or that particular additional session judge may sit for the disposal of cases at such place or places in other division or other district as the High Court may direct. Fifth, where the office of the session judge is vacant. In case where the office of the session judge is vacant, what will High Court do? The High Court will make arrangements for the disposal of any urgent application or any urgent case which is or which may be or made or pending before such court of session by an additional or assistant session judge. Or in case if there is no additional or assistant session judge, that particular power or that particular post or office will be given to the Chief Judicial Magistrate in that particular district or session division. And every such judge or Chief Judicial Magistrate shall have the jurisdiction to deal with any such application. They will have the jurisdiction of the sessions judge. Okay. Sixth point. The court of session shall ordinarily hold its sitting at any place or places as the High Court may by notification specify. The court of session shall ordinarily hold its sitting at such place or places as the High Court by notification specify. But if in any particular case the court of session is of opinion that they will sit in such particular place where there is general convenience of parties and witnesses, there they will sit. In other places in the sessions division in that particular district area only, it may with the consent of the prosecution and accused sit at that place for the disposal of the case or the examination of any witness or witnesses therein. The prosecution or the accused both consent are required. Now explanation. For the purpose of this code, appointment here does not include. What it does not include, it is given in the explanation part of section 9 of the CRPC. It says the appointment does not include the first appointment, that is appointment by the governor with consultation with the High Court, or posting or promotion of a person by the government to any service, or post in connection with the affairs of union or of a state where under any law such appointment, posting or promotion is required to be made by a government. Now we will discuss the appointment of district judges. According to Article 233 of the Constitution of India, all district judges are appointed by the governor in consultation with the High Court. So here actually it is written that the governor is the main person who appoints the district judges, but he appoints with consultation with the High Court. Okay. Now we will discuss the power of court of session. So here according to section 28 subsection 2 of the CRPC, the session judge or additional session judge may pass any sentence authorized by law, and if session judge or additional session judge pass sentence of death, then such sentence shall be subject to confirmation of High Court. Here in the second line, sentence means life imprisonment, death sentence, or even fine. So here session judge or additional session judge may pass any sentence authorized by law. It can be life imprisonment, death sentence, or even fine. And if that particular session judge or additional session judge pass sentence of death, then such sentence of death shall be subject to confirmation of High Court. The session court is the highest criminal court of the session or district. It deals with the cases relating to serious offences such as murder, robbery, and dacoity, etc. It has the power to pass any sentence, including life imprisonment and even death sentence. However, in the case the session court passes sentence of death, the proceeding shall have to be submitted to the High Court as per provision of section 366 of the CRPC. Here I have already said that in the case of session court, if the session court passes sentence of death, the proceeding of that particular case or records have to be submitted to the High Court as per provision of section 366 of the CRPC. And then the sentence of death shall not be executed. The session court or the session judge cannot execute the sentence of death unless that particular case or record is confirmed by the High Court. Section 366 subsection 2 says that court passing the sentence shall commit the convicted person to the jail custody under a warrant. Normally we call this reference for confirmation of the death sentence by the High Court. It means that the session court refers that particular case to the High Court for confirmation for passing the death sentence. The purpose behind enacting subsection 2 of section 366 is to make available the prisoners, make available the offender or the prisoners or the person who has committed the such offense when the sentence is required to be executed. He is to be kept in jail custody, and now this jail custody is something different from the custody of a convict suffering from simple or rigorous imprisonment. This jail custody is only for making that person available when the sentence is required to be executed. I hope this video is clear to you. If you have any doubt, please do comment. And if you like this video, press the like button, share it, subscribe for more such videos. Thank you.